Dear Chief Acosta, my father had a misunderstanding with his employer over some lost office items, but he was able to sort it out because his co-workers attested that those items were not lost, but were in fact not delivered to their company by their supplier. Despite my father having sorted out what seemed to be a mere confusion, his employer still filed a complaint against him for allegedly stealing those items. If the fiscal dismisses the complaint, which we are confident will eventually happen because we have the evidence to prove that the items were not delivered to their office, so it is impossible that he stole them, can my father file a case for malicious prosecution even if the complaint against him was only before the prosecutor's office and did not reach the court? Marvin.
Dear letter sender, an action for damages on account of malicious prosecution is a remedy recognized under our laws. But what is malicious prosecution exactly, and what are the elements that need to be established? As pronounced by our Supreme Court in the case of Sosmeña versus Bonafé et al.,
in Magbanwa versus Hunsay explains the cause of action of malicious prosecution. In this jurisdiction, the term malicious prosecution has been defined as an action for damages brought by one against whom a criminal prosecution, civil suit, or other legal proceeding has been instituted maliciously and without probable cause after the termination of such prosecution, suit, or other proceeding in favor of the defendant therein. While generally associated with unfounded criminal actions, the term has been expanded to include unfounded civil suits instituted just to vex and humiliate the defendant despite the absence of a cause of action or probable cause. The statutory basis for a civil action for damages for malicious prosecution are found in the provisions of the new Civil Code on Human Relations and on Damages, particularly Articles 19, 20, 21, 26, 29, 32, 33, 35, 2217, and 22198. To constitute malicious prosecution, however, there must be proof that the prosecution was prompted by a sinister design to vex and humiliate a person, and that it was initiated deliberately by the defendant knowing that his charges were false and groundless. Conceitedly, the mere act of submitting a case to the authorities for prosecution does not make one liable for malicious prosecution. This court has drawn the four elements that must be shown to concur to recover damages for malicious prosecution. Therefore, for a malicious prosecution suit to prosper, the plaintiff must prove the following. 1. The prosecution did occur, and the defendant was himself the prosecutor, or that he instigated its commencement. 2. The criminal action finally ended with an acquittal. 3. In bringing the action, the prosecutor acted without probable cause. And 4. The prosecution was impelled by legal malice, an improper or a sinister motive. The gravamen of malicious prosecution is not the filing of a complaint based on the wrong provision of law, but the deliberate initiation of an action with the knowledge that the charges were false and groundless. Malicious prosecution does not only pertain to criminal prosecutions, but also to any other legal proceedings such as preliminary investigation.
Applying the foregoing, we submit that your father may file an action for damages for malicious prosecution even if the complaint that was filed against him did not reach the court, provided that the preliminary investigation therefore resulted in the dismissal of the complaint due to lack of probable cause. Further, he must be able to establish that there was legal malice on the part of his employer in instituting the complaint against him. We hope that we were able to answer your queries. Please be reminded that this advice is based solely on the facts that you have narrated and our appreciation of the same. Our opinion may vary when other facts are changed or elaborated. Tomorrow, we'll look into another question from our viewers and readers of Dear PAO. This is your host, Dr. Presida V. Rueda Acosta, DSD, the Chief Public Attorney of the Republic of the Philippines. Goodbye for now.